All right, today in this section, we're going to take a look at two different aspects. One of these is affirmative action, which is a response to the indifference toward minority groups as far as government and the business world goes. And then we're going to be taking a look at interactions of homosexuals within ruling of the court as a minority group. So, starting off, taking a look at affirmative action. The concept of affirmative action is the practice of preferential hiring for applicants of a minority status. So, essentially, it also depends too on how and what you identify as racially. So, the concept is if you have two people applying for the job, one is a minority and one is not, and they are equally qualified for the position, the minority should be deferred to as the one that is actually hired to, again, kind of erase the stigma applied to slavery and all the other uh, concepts of poor treatment from historical wrongs. Now, this, though, can also lead to what's referred to as reverse discrimination. This is where, if you notice, like in the picture here, you have the three white people, and then below you have the African American minority, and the minority, though he does not meet the requirements of where the white people are at, is then given preferential treatment. And again, these two can be combated out and are generally referred to in the same concepts where they come up. So affirmative action is again preferential hiring of equal applicants and just simply having the minority have the preferential treatment if all things are equal. Reverse discrimination is when a minority gets a step up when they don't actually meet the requirements. Cases, Grutter versus Bollinger is an affirmative action case in the sense that the minority was given the benefit even though all things considered equally. If we look at Gratz versus Bollinger, this was a case of reverse discrimination where Gratz met the standard, but what happened was the University of Michigan favored minorities over her that didn't meet the qualifications. Okay, so these were two landmark cases in regard to this particular one. Now, when we look at gays or homosexuals in the Constitution, the first major case that comes up is Bowers versus Hardwick. Essentially, what happened was a police officer had looked through a window in Georgia and saw Mr. Hardwick engaged in consensual sodomy with an individual. He was arrested and both parties were detained, and the court had originally applied the idea that they were in fact guilty of violating the sexual laws of Georgia at that particular time. Now we have another case which was very interesting called the Boy Scouts of America versus Dale. This one took place in 2000. Dale was an Eagle Scout and later was an assistant scoutmaster. And he was also, though, a gay rights activist. What had happened was he was then dismissed by the Boy Scouts, claiming that they were a private institution and that Dale was, in fact, violating their freedom of expression. The idea that the Boy Scouts did not promote or accept homosexuality as a typical norm. Dale, who resided in New Jersey, sued under the grounds that the Boy Scouts of America used public accommodations, and that because they used public accommodations, they could not discriminate against his sexual orientation. The Rehnquist court ruled that as a private organization, the Boy Scouts of America did have the right to dismiss Dale under the grounds that they did not willingly promote homosexuality, and that to allow Dale to do that would condone such behavior. And again, the Boy Scouts were a private organization, and this was what the ruling had concluded. Then we get to Lawrence v. Texas. Essentially, this one is a really interesting case because police responded to a arms or weapons violation. They went into the house and came across Lawrence and Tyron Garner engaged in consensual sex. And essentially, what had happened was they were arrested for violating the indecency clauses of Texas. And essentially, what happened was the court, in a more liberal ruling, changed its turn and effect overturned Bowers versus Hardwick, saying essentially that the individuals had a right to privacy within their own home. And this essentially made homosexual actions federally okay.